Hi, my name is David Cook, and I'm one of the business law attorneys here at Cook & Gore. Today we're going to be talking about covenants not to compete, and this is actually going to be a two-part video. We're going to be talking about ways that you can restrict your employees and independent contractors from leaving your business and then taking your customers and or competing against you. So in this video we're going to be talking about covenants not to compete. The next video we're going to be talking about some other types of covenants that you can have with your employees and independent contractors to restrict their ability to hurt you. So the first thing that we want to talk about is a covenant not to compete. This is where you have your employee or your independent contractor sign an agreement stating that they will not, for a certain period of time, compete against you in any business in your industry. So they can't go to work for a competitor of yours anywhere in a certain geographical area. Now, the courts don't like this because they don't want people to not be able to work in their chosen profession. They will uphold them, but they do have to be reasonable. These covenants have to be very reasonable. The courts have held in Texas that this reasonableness factor really considers the geographic scope, the scope of time and place, and then also the scope of what they're restricted from doing. So first, as to the geography, you can't restrict them worldwide typically. Typically you can't even restrict them from working in a competitor nationwide. You probably can restrict them from working in a competitor in your city and maybe in your surrounding counties. It's also been held that in certain instances where the employer has a strong enough reason, they can restrict them even within the state of Texas. So we recommend that you really think through how much you do need to restrict them in terms of geography. In terms of time, you can typically state that they can't work in a competing business for 1 or 2 years, and then as much as 5 years has been upheld to be reasonable in certain instances where the employer can show an overriding reason for having that long of a time limit. And then third, it's got to be reasonable in terms of scope. If your salesperson is selling books and your covenant says that they can't sell anything, that's too restrictive. You can probably restrict them from selling books with a competitor, but you probably can't restrict them from being a salesperson just in general of cars or any other item. So those three things are really the keys, and you really need to sit down with an attorney to make sure that you're not writing it in an overbroad manner. If you have your employee sign something that is too overbroad and restricts their rights, it can actually be a double-edged sword and cause you great harm if you ever try to enforce it. So make sure to talk to your attorney. If you draft these things well, they can be very effective, but if you draft them poorly, they can really end up costing you thousands of extra dollars in attorney's fees that you would not need to have, and they can end up being unenforceable. So it's important to talk to your attorney. We're happy to help you. We're happy to help answer any questions that you have. Give us a call at 214-236-2712.